Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the K-1 fiancé visa, specifically in the context of denial of those type of visas. And a question that often arises from folks who contact us and just from folks I see on the internet and comments on various forums and things is the question, are denials fairly frequent in a K-1 context? Well, generally speaking, in the past, it has not been my belief that the immigration apparatus is particularly looking to deny people for fiancé and marriage visas. That being said, it does happen. Most notably, it happens when there's what's called a legal ground of inadmissibility present in a given case. So things like crime involving moral turpitude, drug crimes in the past, overstay in the past in the United States, prostitution, things of this nature can result in a denial of the ultimate visa. But with respect to this video, I'd like to note that moving forward, we're filming this video just prior to September 11th of 2018. And on that date, there's going to be a rather significant change with respect to the underlying policy that USCIS maintains with respect to issuing what are called requests for evidence. In the past, it was incumbent upon an officer who's adjudicating a given K-1 visa application or a petition at USCIS to go ahead and issue an RFE where they could not determine, unless there was no possibility that the visa could be issued ultimately. So basically what you're saying here is, a case where a married couple is applying for a fiancé visa. In that case, it's clear that as of the time of the filing, they were not eligible for a fiancé visa, and therefore they could be denied. That policy, that was in effect, and that was a very narrow subset of cases that were going to be denied based on that. In most cases where it was just a documentation deficiency, what's called a request for evidence would be issued, and either the couple or their attorney could go ahead and follow up on their behalf, rectify the insufficiency, and move forward with the approval of the petition. That's changing. The new policy goes ahead and rescinds this no possibility doctrine, as I call it, and basically is putting into effect a regime in which if you're deficient and it's not clearly evident from the initial filing that the couple is eligible for the benefits, a denial can occur. I don't know how this is going to play out yet, but I'm doing this video because I think it's possible we could see more denials of K-1 petitions in the future, especially cases where it's a bit ambiguous as to whether or not the couple actually met in person, whether it's ambiguous as to when the couple actually met in person. As most may be aware who are watching this video, K-1 fiancé needs to have met with their American citizen counterpart physically present meeting within 2 years prior of the filing of the underlying petition. In certain cases, that may not be immediately evident from the filing of the case. And for this reason, although denials were not particularly a big issue in the past, at least at the USCIS level, I think moving forward, it's pretty safe to assume that scrutiny is going to be much more heavy on these petitions. And the scrutiny that was provided before, which had sort of, for lack of a better term, a safety net in the form of an issued request for evidence, that safety net, I think, is going to be pulled away in many circumstances, and you may start seeing a much higher percentage of underlying case denial in petitions for K-1 fiancé visas simply because of this change in policy.